All right, so patent triage for tech startups. So, yeah, thank you again for hosting me. Thank you, Catalyst and Dennis. Appreciate it. So today is just kind of like a quick presentation. I won't say that quick, but a presentation on what you can do to preserve patent rights and spend as little money as possible, but not totally blow your patent rights up. And I'm going to start with kind of like a general primer on that and just basics, a few slides so I can talk to you about the consequences of what can happen down the line. So there's three types of patents. There's plain patents, which aren't really appropriate for this context, but they're there. Be aware that they're there. And typically for people who are...
That's weird.
You'll know if you need a plain patent.
That's funny.
Design patents, also probably not germane to the tech startup, but they're there. They protect the ornamental characteristics and design of a product. You know, basically the look and feel, but they are actually quite powerful and have been used in the tech industry. For example, Samsung and Apple's big battle. Part of the infringement was on the design patent for the original iPhone. The actual look of the black slab, bezel design. They all look the same now. And of course, there's utility patents, which are the most popular and the ones that are usually germane to the tech startup. And again, they're for new, useful, process, machine, article, manufacture, composition, manner. It's pretty standard. It's pretty broad and includes software inventions. So within the subtype of utility patents, there's what's called a provisional patent application. So there's the full patent, non-provisional utility patent application, and there's the provisional patent application. Provisional patent application is definitely going to be more useful to the startup. They establish your effective filing date. They don't have any of the formal. They have very few formal requirements, if anything. So basically, you can take a cover sheet and put it on a white paper, or put it on your software spec sheet. You can do all sorts of stuff with it. I mean, there's no requirement. Now, they're not looked at, and you got 12 months to convert them. And the reason why we talk about the effective filing date, so I'm going to skip ahead here. So I'm actually going to skip ahead of this, right? This slide is, so conditions for obtaining a patent. So it's got to be eligible subject matter, which is usually not a problem, but I'm going to get to that in software. Okay. And it has to be new or novel and non-obvious. And non-obvious is basically the standard to prevent you from getting a trivial patent on a trivial change, so to speak. They want it to be something substantial. It doesn't have to be a massive change, but that non-obvious is the artificial standard that they've established in the patent jurisprudence. And so that brings me back to your filing date. So why isn't the filing date relevant? Well, that new and non-obvious is based upon the technology as it sat the day before you file. So every day, and the more stuff becomes available, published, available on the internet, it actually gets harder to get a patent with every day that passes. So there's more we call it prior art, which is the old technology is available and can be used against you. So that's why the provisional is helpful. You don't have time for a utility application, which has a whole bunch of parts right here. It takes time. Provisional can be produced if necessary, if needed, within one day, and you can get your filing date. And the real problem could be if you're about to disclose yourself. That filing date, any filing date, definitely before you actually disclose, is quite helpful. So, if you have any questions, because on these slides I'm skipping around.
So if you have a provisional, it said it was not examined.
Yes.
Does that mean there's no real prior art check for a provisional?
It just gives you a filing date. They basically will give you an official filing receipt saying we received it, 20-something pages, this is the date, thank you. And
so then you go to do the utility one, and then you want to look back at your filing date, I guess, for what prior art existed the day before.
They go to the provisional.
Okay.
So because the problem, in particular in software, can be, you're about to disclose or you're going to launch, and you don't want your own technology used against you, because that's what can happen in certain jurisdictions. Wow. We found your product was available before you filed, so you're not going to get a patent over yourself because you're clearly not going to be new.
That's weird.
I know, right? It totally makes no sense, but that's what You know, good news is the United States isn't like that. So the patent grant, just again, I'm going to blow through the patent. You know, what is a patent? So it's basically a federal right. It's a limited monopoly on your technology that the federal government gives to you. And oddly enough, it's actually not a right to practice your invention. It's counterintuitive. There's a lot of things in patents that are sort of counterintuitive. This is one of them. You might actually have an improvement patent, right? That's what was in that slide a couple slides ago. And so if you have an improvement patent on a technology that's already patented, you only own the right to the improvement, not to the base technology. So you actually can't even make the product without infringing someone else's patent. Now, they can't make the improved version without your patent. So technically, a patent is only a right to stop other people from making, selling, or using your patented invention. So that's the only right you actually have. So you have to go to federal court to enforce it. So patent term, 20 years from the earliest priority filing date. Continuation divisional applications or the clone applications, you don't really need to be worried about that just yet. Parts of the utility application, the reason why it's sort of complicated to kind of prepare them, you got to have each and every one of these sections.
Can you go back to the provisional patent?
Yes.
I didn't read through all the...
My apologies.
Okay, so there's not examined. Now, once you file that, you can what can and cannot you do in terms of disclosure or what?
Well, what can you? So basically, what rights? What has changed? So you filed your provisional. Well, one thing is patent pending technology. That's just a marketing issue, but it also puts people on notice that patent rights are pending, literally, on your technology. Now that you have a filing date, if you're going to disclose, you've protected yourself from affecting your patent rights. You've also started, let me think here, make sure all the consequences. So you got your filing date, you can disclose without effect to your patent rights, patent pending. I think that's basically it. Okay. I might be forgetting anything. I love how we're recording this, so yeah. I'll add it to the comments on the YouTube video.
Yeah. But the major point is that you can disclose.
What
you will within a year.
Yeah, it's within
file as a full-blown utility patent.
You'll no longer affect your patent rights now. If you
the thing is, what about all the? Here's me as an amateur, right? So when you file this provisional, there's all these claims in the end, in the full-blown patent. You're making all these claims. Do you have to have, when you make a public disclosure, do you have to have thought about all of those claims so that you don't?
I mean,
you don't.
Are you worried about like the effect? I mean, like, when you disclose your patent application, or I mean, the publication of your patent application? I guess that brings me to another element of provisionals. If you don't convert them, they do not publish. So if you decide halfway through that process, you're like, you know what? We looked at it; it's not patentable, but we want to keep this as a trade secret. It's the back end of our software. I don't want people to have this. You just let it go expired, it never publishes, and you can maintain it as a trade secret. Now, when it does publish, when you file a utility, 18 months from your earliest filing date, which would be your provisional, it's going to publish. You can avoid publication, but if you eventually get a patent, you cannot avoid publication. And when it publishes, it'll publish, an issued patent publishes with the claims. Now, a published application, utility application, also will publish, and it has claims. So what do those claims do? They do put people on notice. In certain circumstances, you can actually, typically the rule is you only get infringement, you only get damages from the time the patent's issued. And in certain circumstances, you can reach back pre-issuance if the claims in the published application cover the technology that's allegedly infringing. So that's probably a little bit too complicated. I wouldn't be too worried about it. We do draft provisionals. Good practice is to draft provisional applications, although there is no formality requirement with provisional applications. When you come to us and say draft a provisional application, good practice is we draft them pretty close to a utility. We basically, it's almost like a really rough draft of a utility application.
Yeah.
And that's typical.
put down, well, that's what I'm thinking would be useful for the entrepreneur, is to know, to have it codified. Be thinking about what the claims are already.
Oh, absolutely. And when people look at your provisional, when you're trying to decide, well, should I license this technology? The claims kind of give them an idea of where they need to be, because they'll most likely take it to a patent attorney who will look at it and say, well, this is what they're looking to get, or this is a provisional until they actually get an issued patent, another thing. So, patent right, 20 years is the term, parts of the application. I want to get you guys to the meat.
Yeah.
So, this is something for software guys. So, that first barrier, eligible subject matter, for the longest time, that was like the one foot hurdle or the 2 foot hurdle. No one really worried about that. Everything was pretty easy. Recently, the Supreme Court and the Alice Corporation versus CLS Bank decision, is it 2 years ago or maybe 3 years ago? They gave some real meat to that hurdle, particularly in software, in business methods, and even more so software, and definitely in business method implemented software. Or software implemented business methods. That hurdle became much higher, much more difficult, with a moat in front of it, and spikes and a pit of death after past it. So I mean, it really became it's become much more complicated. And each invention has to be evaluated independently, but that's something you can deal with when you file a utility application. But I always tell my clients in software, be aware that's out there, and that's out there, and that can be a problem for patentability down the line. Novelty is pretty straightforward. The way the patent office decides novelty is if they can find each and every feature of your claims within a single prior art, right, old document, prior art document, it's no longer novel.
Actually, can we talk about that some more?
Yeah, please.
All of the elements of the claim cannot be present in a single prior art reference. So you can combine a bunch of things that other people had talked about, written about, or whatever. You can combine them into yours and make your own patent of this.
Absolutely. That's okay. And so, and the way they deal with combinations. So let's say your invention is disclosed in a prior art document except for feature X. It's the new feature.
Okay.
So what the examiner will try to do is say, all right, X is not, and I can't find X in its prior art document. Let me go find it in another reference and try to combine them. But you can't just arbitrarily combine stuff. There's actually an established regime on how things can be fairly combined. You got to have like a logic, or you're going to add like a social media conduit. Oh, that's your novel feature over the old technology. The examiner is liable to say, well, people are adding social media conduits to everything. It's part of the API. That's obvious. Like that would be considered obvious. You'd have to have a little bit more. And of course, in that non-obvious standard is another artificial legal fiction is the person of ordinary skill in the relevant field, and basically it's a guy with a bachelor's degree and a couple of years of experience. It's just kind of shooting from the hip. It's what we all try to aim at. We really don't get that granular. It's usually it's unfortunately a subjective standard. Yeah. So timing issues. We're the first inventor to file system. So you're getting this back to the provisional. You're rewarded by filing earlier. Every day it gets harder to get that same patent because more technology is published, more patent applications are available. And again, the prior art is anything that's available to the public the day before you file. So everything, patents, patent applications, Google, web. It can be a university white paper database so long as it's accessible to the public. So white papers will show up sometimes. It just depends. Sometimes you'll get a manufacturing spec or manual for software from like 20 years ago. Examiners are able, and those are the bureaucrats at the USPTO, have access to almost everything. They have incredibly good access when it comes to databases there.
We talk about that last one a little bit.
Mm-hmm.
So you mentioned how the provisional patent gives you that earlier filing date. Mm-hmm. Is this saying that prior art means it has to be something that existed a year before that date?
1 day before the filing date. The day before.
What is this talking about? This was made more than 1 year before the effective filing date.
Yeah, that's another thing we need to talk about.
Okay.
So in the United States is actually kind of cool. So remember that situation I was telling you, your own stuff can be used against you? Mm-hmm. In Europe, in certain jurisdictions, I think China is one of them, they're what we call absolute novelty. Like they don't care who disclosed it. If it was you and you filed the day afterwards, tough luck. It's good. They're going to use your own stuff against you. The United States, on the other hand, has had a 1-year grace period for the last 50 years. So basically, the way the rule works, if you disclose against yourself, you may have destroyed your European and Southeast Asian, Chinese patent rights, but the United States, you got 1 year. So basically, everything's prior art that's not you the day before you file. But you get a year prior for your own disclosure. So they won't use your own disclosures against us.
Now,
yeah.
Is a disclosure explaining how it works, or can you just say, I have this product, you don't know how it works, but this thing exists, and a year goes by, and then you say, I want to file how this thing works?
It's tricky.
Okay.
And for just publications, if they're not enabling, it may not be a problem. Enabling means there's not enough detail for someone to actually make. If it's a totally high-level abstract, 30,000 feet up view, and it's not enough, it shouldn't be a problem.
Okay.
But it can get a little tricky.
Okay.
So marking, this is not that important. You get a patent, you mark it patented, patent pending when you got a patent application pending. All right, now we get to the meat. So typical startup parameters. Stop me if I'm wrong. So you got very little money, self-funded, friends and family. So people are really careful about spending their money. So when a patent attorney shows up asking for $3,000 or $4,000 to file provisional, you gotta spend your money appropriately and wisely. Few, if any, full-time employees, mostly contractors, friends, and product not launched or only small-scale commercial development, which again, depending on how it's launched, could be a disclosure issue. Technology may be evolving, changing more dramatically if a pivot is occurring. So basically, all the worst things that could happen, for a patent person. So employees, contractors, friends. All right, so you're a startup, you got all sorts of people working for you. The problem with that is it can jeopardize ownership of your technology. So you bring a friend of yours who works for a local software company. He's like, hey man, I'll help you out. It's right in my forte. I'll do it at night. Or I'll do it at lunch hour at the office. This can be a problem, for several reasons. One, by default, patents belong to each and every one of the inventors equally.
The inventors.
Yeah. By default. That's the default rule. So if he's an inventor, you see the problem. He's already an owner in your IP, which is a problem. And when you're going to funding, venture capital funding, or even you're being acquired by a larger company, they're going to do their due diligence. They want to make sure all the intellectual property is locked up. Like they know the company owns it because we want to make sure we have it locked up. We don't want to have a loose inventor who's not part of the company who's yet to assign. It can hold up funding. It's a problem. And so to change the default, you either got to have an employment contract, or in certain circumstances, the state of Florida law can operate the transfer informally. Again, you want to have that contract in place. Basically, the way it works, if your scope of employment is to design and to engineer, and it's within that scope for the employer, you could argue you'd have to take it to court, but the law seems to suggest that it would transfer to the employer. But no one wants to rely on that. They don't want to litigate that. They want an employment agreement or a work-for-hire agreement, something saying that, hey, Bob's working for me. He's doing this on the side. Everything, if he's an inventor on anything, he transfers ownership to me, to the company, and establishes the control of those rights. And so that's what you definitely want to do. Now, here's another thing that pops up. The buddy who works for a local software company, he may want to assign his rights to you, no problem, no issues, but his company may not.
Right.
So in a certain circumstance, if it's within his field, and if it's within his field and he's using company resources, the company has an argument to own that technology too.
When I worked for Disney, it said very clearly in their development contract, anything you can create on their software or in their offices belongs to them, even if you get it from somebody else. That's why you got to be careful. Yeah, that was one of the reasons I left there.
Does anyone watch the HBO show Silicon Valley?
I do. It's hilarious.
It came up. It was actually this season 2 where he's like, "Oh, I used my Huli laptop to compile the code." Now that was a very minimal use, off the clock, at home, company resource. I don't know the state of California law. That's what would govern. In that show, they made it seem like even a minimal use permits the company to claim ownership. I don't believe that to be the case. Florida, that's not the case. It just depends. Now, it gives them an argument,
Sure.
a leg to stand on. So that's why you want to be very clear. So if you got your friend, Bob, he works for a local software company, for example, with Disney. You say, I want to help out. Bob, you got to do it at night. You got to keep track of your time. You need to make sure you're using your personal laptop. It's even better to have, if he doesn't have one, all he has is his Disney issued one, loan him one.
Yeah,
It's better to give him one than use my laptop. Don't ever use the company resources. And that's the fair thing to do. So go ahead.
Just a local knowledge for those of you who may know Code School, which is a local company that was acquired a few years ago. I know some of the attorneys involved in that transaction, and this was a very big problem. The code, there were so many independent software contractors who had been involved in the development of that company, and their IP was not assigned to the company. And so they were in the midst of the acquisition. This is a $36 million acquisition. And attorneys were running around the country, literally, rounding up all of these people and to get them to assign their rights. And that's companies in a very vulnerable position, right? Because now the employee knows that, oh, you need my assigned rights because you want to make $36 million.
Yeah.
I think I want a piece of that, right?
I have personal experience with that. They do know, even though it may not even be disclosed, because, for example, a lot of these corporate acquisitions, they're kept under the radar because they don't want any insider trading issues. And so they're confidential, or it's totally confidential until it closes. And then there'll be a press release that so-and-so's acquired company B. Well, when you show up, when an attorney for a corporate law firm contacts an inventor who hasn't worked for the company in 10 years and says, I need you to sign this assignment for your company that was purchased by A, B company, which was purchased by C company, they know something's up.
Yeah.
They know you don't sit a corporate attorney to hassle them over a 10-year-old technology unless it's worth something to you. And so they tend to be difficult to deal with. I have heard that some outlandish demands, to call them, be polite about it. Some people may call it extortion, but they know they have leverage. It is not a lot you can do. I mean, time is of the essence. You don't have time to drag them into state court. So basically, you want to lock down all that stuff. And that is totally right. These things will trip up acquisitions. It makes your head explode. Where you're being acquired, you're like, this is the old code. We're not even using this anymore. This technology is totally garbage. We don't even want to use it anymore. No, it's a problem. It is literally a punch list for the acquisition, and it's holding up the whole acquisition. And so that's why you get like frantic attorneys running around, and you get these outlandish demands, and you get pressure from clients to close this transaction. So you got to do what you got to do, and sometimes it includes paying outlandish fees for the privilege of having someone sign a contract they're obligated to sign under their employment agreement. So again, anyone working for your startup needs to be presented with a non-disclosure agreement and an employment agreement. The non-disclosure is just a nice thing to have. You might as well. And before they do any work, before they see your technology, before they touch anything, they need to see these things. And this needs to be done before work begins. Do not rely on informal gentlemen's agreements, emails, promises, etc. I'm going to mail you a letter, handwritten. I'm not going to. The history of legal startups and corporate America is littered with people being, given the shaft. Has anyone seen the movie The Founder?
Oh yeah, about McDonald's.
Yes.
Yeah.
The very end, Ray Kroc, he tells the McDonald brothers, they're like, oh, we want 2% of gross revenue, profits for perpetual rights to that. He's like, there's no way we can do this deal, but you got my handshake on it. And it looks like it's totally melodramatic and added for dramatic effect, but that's exactly what happened. That is exactly what happened. It was a gentleman's agreement. I will give you 2% of the billions I'm going to be earning in the next 25 years.
Yeah.
He did not pay them anything.
And
that's all he was up. A gentleman's agreement has no enforcement other than honor. And again, big fan of Game of Thrones. You see how far honor gets you. It's just, you got to have a contract. Contract or an army. In Game of Thrones, army is much more helpful. So don't rely on it. Get an agreement in place. again, you don't want to spend money on an attorney, so the internet is your friend. Form is better than nothing. I always tell people forms are littered with pitfalls. They are dangerous. But if you're telling me, I'm going to disclose my technology, I can't afford an attorney, I'm just going to disclose it to them, you're better off getting a form than nothing. And try to get one that fits for the jurisdiction you're in, state of Florida, state of California. Something's better than nothing. And of course, each one of these contracts is governed by state law, so even in Florida, it might be better than nothing. But in some states, you might want to check with your local jurisdictions. But I think the general rule does apply. Something, particularly non-disclosures, because the worst thing is they're just not enforceable, which leaves you in the same position you would have been previously, which is nothing. So I definitely recommend those. They're not the best, but it's better than nothing. All right, so patents. We talked about public disclosures. Limit them until absolutely needed. No public betas, alphas. Make sure they're closed. And make sure your terms of service, which almost you can always get a generic terms of service, but make sure your terms of service includes that the confidential nature, that by you're agreeing to the confidential nature of this beta testing before you download and install the app. And again, this prevents it from being considered a disclosure. Again, this can affect the value, again, of your company. U.S. rights, you got that 1 year. But if you affect your European rights, it could be a problem for a large company. They're looking at it, and they may want to pursue those rights, but if they've been blown up, it could affect the value. Alpha, beta releases, keep it closed. Terms of service, talked about that. IP audits can be helpful in directing your efforts. So, all right, you can't afford a full-time attorney. Can't afford, several $1,000s. It might be worth to hire an attorney and keep him on retainer. And again, basically pay him for his time to come in, take a look at what we got. Is there anything we need to be protecting, and keeping confidential? And they can kind of give you, an attorney such as myself can kind of give you the shoot from the hip. Again, the value is, it's best to hire an attorney, but this is another option. You can get someone to come in and just for a very limited representation and kind of point you in the right direction. Do-it-yourself searches are helpful because, again, if you look at it, you're like, oh, I can go find this technology out there. If you do, and it's not novel, it's not patentable, so you don't need to worry about it. All right, so let's say your disclosure cannot be avoided. It's just going to happen. Just can't avoid it. Maybe my angel funder is making me do a limited commercial release. All right, pro se efforts at filing a provisional application. Again, technically, the only form you got to fill out is a one-page cover sheet, and you can file it on your own. Now, what can you do to make that effort less disastrous down the line? Because let's say you get acquired or you get some funds from that commercial release and you want to have a patent attorney come in. The more you put in it, the better. The more disclosure, the better. But the counterweight to that is that it will eventually be published. So don't put any trade secret-y type things in there, anything you want to keep private. Again, you can abandon that provisional and lose that date. But in the instance when you have to disclose, when you're going to disclose, and you're going to file something to protect your rights, consider that could eventually publish. So don't put anything sensitive in there, because it will be available to the public for inspection. Using an attorney, again, if you can, it's preferred. People think, oh, a corporate attorney is going to be several $100s an hour. I can't afford them. I don't want a giant bill. And the patent procurement business is largely fixed fee, particularly in software and electronics. So if you can get a budget that you think you can afford, approach it to several attorneys locally and see if you can negotiate a deal. Show them the technology and see if they can work with your budget. There's also deferred billing arrangements. You can work it out saying, we're doing a limited release, can't pay you right now. If you hold our bills, there can be arrangements such as that can be done. Equity exchange in limited circumstances. Everyone wants to do an equity exchange. And it was in Silicon Valley in the late 90s, in the early odds, it was all the rage because everyone was, patent attorneys were thinking I'm going to become a billionaire by prosecuting these patents. So they did a lot of equity exchange in lieu of fees, which can be good and can be bad. Bad, it blows up like it did for a lot of firms in Silicon Valley. But also the more problematic issue is not just the risk of it, which, you're putting your own skin in the game, which can endear your client, particularly a tech startup. But there's also ethical considerations for attorneys. It's actually really complicated to have a business transaction with your existing client. There's a lot of protections in there because, again, all the ethical rules for lawyers is they need to deal reasonably and fairly in all aspects with their clients. And a business transaction is no different. So that's why people want to do this. That's the first thing people go to. But I tell them it's really complicated to do. And if you can do anything else, deferred is a better arrangement because that can be done immediately. And then you got to negotiate the equity exchange. It's a whole other transaction. And then that attorney can't represent you in that transaction. You have to hire another corporate attorney to look at it and tell you, well, don't give him this much because then he's going to be able to own your company. Again, I'm not a corporate attorney, but I would tell my clients that, oh, you want to do an equity exchange? Happy to do it. If I'm, but you need to get your own corporate attorney to review the documents outside of me. So it just doesn't make sense sometimes. Defensive publication. So if you decide you're not going to pursue a patent, it's not patentable. You don't think it's patentable, and it's going to be out there anyways, you may want to file a publication with the USPTO, which you can do. So it'll be searchable, readily searchable by the USPTO examiners. You can also publish it on the internet. You don't have to formally do it, but just make sure it's out there and available. And that's to prevent competitors from gobbling up your technology with their own patents. Because that can happen. That's kind of the consequence of not filing, is that someone else could file, as long as they independently invented it. If they file before you, even though you may have conceived of it, if you're sitting on it, and a competing technology company in Northern California decides to file on it, even though they conceived of it independently and subsequent to you, they filed before you, we're a first inventor to file. And basically what that says is, as long as they didn't steal it from you, they would get the patent. Now, you may have some defensive rights in that you've been using it before the filing of the patent, but that's a whole other discussion. So it's time to convert. That 1 year is coming. What are you going to do? I mean, you're still in the same situation, low budget, low funds. One option is to refile the same provisional application. Take it and refile it again. Now, you lose your priority date. You can do that if you haven't published, if you haven't disclosed. It's still incrementally harder, but you can do that. I'm not a fan of it, but people have done it. At least you keep the patent rights pending.
So you refile, and the date you refile is the new date.